Hello everyone, my name is Suvaroop and welcome back to another video of CLATapult. Today we will be undertaking a detailed discussion upon the Supreme Court's determination on the existence of Article 31C of the Constitution of India. Recently, Supreme Court of India dealt with an issue with regards to acquiring and redistribution of privately owned property. In this case, the Supreme Court delved into the discussion of the existence of Article 31C of the Constitution. This being a matter of radical constitutional consequence, a 9-judge bench was formed, which was headed by Chief Justice of India D.Y. Chandrachud. Article 31C of the Constitution lays down protection of laws that is made in furtherance of directive principles of state policy. Directive principles of state policy are laid down in Part 4 of the Constitution. These are rights that are not enforceable in any court of law, as opposed to fundamental rights guaranteed under Part 3 of the Constitution. However, Article 31C lays down that if any law is made in furtherance of two specific directive principles of state policy, that is, equitable redistribution of material resources of the community and prohibition on concentration of means of production, laid down respectively under Article 39B and 39C of the Constitution. If any law is made in furtherance of these two specific directive principles of state policies, then that law cannot be challenged on grounds of Article 14 or Article 19 of the Constitution. Article 14 lays down the right to equality and Article 19 lays down the right to freedom, both of which are significant fundamental rights guaranteed under this Constitution. However, the conundrum arises from the very origin of Article 31C of the Constitution itself. Article 31C was introduced back in 1971 in the 25th Constitutional Amendment. This amendment was introduced by the then Indira Gandhi government. The statement of objects and reasons for the amendment itself laid down the bank nationalization case. The bank nationalization case, or as we know it, R.C. Cooper versus Union of India, is a landmark judgment that prohibited the central government from taking control of 14 commercial banks and converting them into state-owned entities. This nationalization process was undertaken in furtherance of the banking company's acquisitions. An 11-judge bench in the case of R.C. Cooper versus Union of India cited Article 31(2) of the Constitution of India as reason for striking down this act. Article 31(2) laid down that if the government were to acquire private property, they had to provide specific compensation or had to lay down the basis on which compensation would be provided to the private owners. The Banking Companies Acquisition and Transfer of Undertakings Act could not pass this test of laying down adequate compensation for the same. The central government, noting that the Supreme Court could now go into the question of adequate compensation, therefore introduced 25th Constitutional Amendment to surmount the problem of enforcing the directive principles of state policy. This Amendment Act, as we know, introduced Article 31C, which laid down that any law that seeks to further directive principles of state policy, specifically relating to those which concern material resources of the society or concentration of means of production, shall not be challenged under Article 14 or Article 19 of the Constitution of India. The 25th Constitutional Amendment was further challenged in a landmark judgment of Keshavananda Bharati versus Union of India, which laid down the scope of amending powers of the legislature. It laid down that if any amendment introduced by the legislature violates the basic structure of the Constitution, then that amending act would not be deemed valid. The Keshavananda Bharati case also struck down a portion of Article 31C that specifically related to the fact that any law would not be struck down merely because it did not fulfill the policy that it sought to fulfill under the specific directive principles of state policy. The years following the Keshavananda Bharati judgment opened the doors for the court to examine whether any law that is passed in furtherance of Article 39B or Article 39C actually fulfilled its goals and purposes or not. In 1976, however, the 42nd Constitutional Amendment was introduced, which brought widespread changes to many provisions of the Constitution. So much so that we now know the 42nd Constitutional Amendment as a mini constitution. This amendment also brought about changes in Article 31C, not restricting its scope to only Article 39B or 39C, but expanding it to any directive principles of state policy. Therefore, the law after the 42nd Amendment stood as if any law is passed in furtherance of any directive principles of state policies, then such law cannot be deemed invalid on grounds of Article 14 and Article 19 of the Constitution. However, the Supreme Court in the year 1980, in its landmark judgment of Minerva Mills versus Union of India, further struck down certain amendments introduced by the 42nd Constitutional Amendment Act. Therefore, it held that the power of amendment given to the legislature under the Constitution is not absolute in nature. It cannot be unfettered. Therefore, there has to be certain restrictions on the powers of the legislature to amend the Constitution. These series of Supreme Court judgments, however, sparked a legal conundrum as to whether striking down a part of the 25th Constitutional Amendment led to striking down the entirety of Article 31C, or does Article 31C exists as it did before the Keshavananda Bharati case. However, in the present case at hand, the Supreme Court is hearing a challenge to the Maharashtra Housing and Area Developmental Act of 1976, which allows the government to acquire cessed properties upon request of the occupants. And the obligation cited is Article 39B, which relates to redistribution of material resources of the community. In 1991, the Property Owners Association of Bombay had filed a case in the Bombay High Court with regards to this chapter of the Act. However, the Bombay High Court rejected this application by citing Article 31C of the Constitution, saying that any law that is passed in furtherance of 39B would not be open to such challenges. This Bombay High Court judgment was then challenged in the Supreme Court, where the main issue became whether privately owned properties would fall under the scope of materially owned resources of the community under the scope of Article 39B of the Constitution of India. However, recently the Supreme Court has expanded the issue to the overall existence of Article 31C of the Constitution itself, and therefore then, since it is a matter of radical constitutional consequence, the Supreme Court has constituted this 9-judge bench to determine the same. Let me know how you think the Supreme Court should deal with this issue. Thank you.